Now turn to the second case on this morning's docket. That is case number 101940, Kenneth Rinehart et al. V. Morton Buildings, Inc.
Greg Musil, Polsnelli Shugart, on behalf of Appellant Morton Buildings, Inc., I'd like to reserve 3 minutes for rebuttal, if I might.
3 minutes is granted.
May it please the Court, Mr. Entz. Our petition for review raised two questions. One, on the economic loss doctrine and its application in Kansas and to these facts, and two, the appropriate award of an attorney's fees on appeal. I intend to spend my time today on the economic loss doctrine. Almost exactly 9 months ago today, you issued the David versus Het decision in which for the first time the Supreme Court addressed the economic loss doctrine as it applies in Kansas. We have a body of case law from the 1990s and 2000s from the Court of Appeals and the federal district courts. But for the first time, the Supreme Court addressed this. I found interesting that in your decision you stated that this doctrine has been difficult to define because of its many permutations, and I'm not sure that truer words have ever been spoken by this court. As I prepared for today to try to establish and identify those principles and policies that might be useful, I find reading those cases from different jurisdictions and from Kansas somewhat difficult to synthesize. The Het decision, probably for that reason, addressed a very narrow issue and had a very narrow holding. In residential construction cases, a residential homeowner has the right to bring negligence claims against a contractor for purely economic loss. The issue today involves different facts and a different scenario. I believe I'm here today and the petition for review may have been granted because this court is seeking to distinguish how we treat commercial situations where a commercial contractor is building commercial space for a business, and whether or not a distinction exists between that and residential construction. If Het is to apply to the facts today, this court must extend Het from residential construction to commercial. It must extend it from a homeowner to a commercial business, and it must extend it from parties in privity to non-privity parties, and allow all of those circumstances to sue for purely economic loss in tort. The businesses in Kansas, particularly contractors or builders or design professionals, need a test that they understand when they're allocating their risks and their benefits, when they're entering into a contractual situation, when they're making presentations to a potential owner who wants to build something, as to their risks, the benefits, and whom they might owe a duty to. In this case, as the Court of Appeals decision stands, a contractor building a building owes a duty to a commercial tenant who might move into that building if they don't build the building on time, if they don't fix any problems on time, and if they don't meet the standards of the industry, which they have said in their contract they will do.
Let's look at it this way. As this case comes to this court, we accept that the plaintiff had valid negligent misrepresentation claims against Morton. So you agree with that? I mean, there's no fight about whether they were valid or invalid because that issue's not in front of this court. There may be an issue about whether the economic loss doctrine bars valid negligent misrepresentation claims. That's really what you're arguing. We've got a valid claim, but is there a legal doctrine that bars presentation of that valid claim, correct? So what I wanted to look at is why does it bar valid negligent misrepresentation claims? And I can't tell from your brief whether it's barred because Midwest Slitting is a related party to another contract between different people, or whether that contract doesn't matter and that related party status doesn't matter, that Midwest Slitting is simply seeking damages for economic loss, therefore the economic loss doctrine applies. You see what I'm saying?
I think that is the most confusing fact of this case. Mr. Rinehart, the single member of the LLC, was part of the negotiations, was part of the allocation of risk, was part of the acceptance of benefits as an individual party to the contract. he had the opportunity to protect against purely economic loss, which I think at its heart is what the economic loss doctrine intends us to do, to protect freedom of contracts so that the society is not relying on the tort law when parties can allocate their own risks. As a person at that table who could allocate that risk, the economic loss doctrine should apply to him.
But is that fact the linchpin for why the economic loss doctrine should bar these otherwise valid negligent misrepresentation claims? Is it just because he's I think you call it a directly related third party in one of your submissions, is it just because of that
No.
that we want to do this?
No.
So it really doesn't matter whether he was directly related or not, doesn't it? We don't. That doesn't matter because you want the doctrine to bar all third-party negligent misrepresentation claims for economic loss, period.
It does not matter. It is a layer that in this case goes even farther as to, do we want contract law to control allocation of risks, or do we want to rely on tort law? In a normal contracting situation, an architect, an engineer, and a contractor may get together and make a presentation to an owner or developer. They may or may not have potential tenants in that meeting. If everything I tell them in that meeting becomes the potential basis for a negligent misrepresentation claim, and although I agree that the district court submitted 3 negligent misrepresentation claims and the jury found them and the Court of Appeals upheld them, if you look at those and under your source of the duty analysis that you did in David versus Head, time of completion of contract, time of completion of repairs, and the quality of the construction, do those arise out of a common law duty of tort, or do they arise out of the specific contractual relationship of the parties?
Well, the jury found that they arose out of negligent misrepresentations, which is the communication of information. What strikes, and I don't mean to dominate this, but what strikes me is that in 1976, I think it was, this court adopted negligent misrepresentation as a tort as defined by the restatement. And nowhere in that analysis, and nowhere have we ever said, and the restatement doesn't say, that privity of contract one way or the other is an element in this tort. So I'm trying to figure out how we bootstrap the economic loss doctrine into the restatement's criteria, which we've already found, for negligent misrepresentation.
Well, I think the issue then becomes, the broader issue that I was talking about today is Kansas appellate courts, Court of Appeals decisions have said the economic loss doctrine applies to strict liability. Strict liability is
only in products liability cases.
It applies.
They haven't done it in a tort where the damages are economic loss. I mean, your only support for the statement you made about applying it to third parties is Northwest Arkansas Masonry, and that's a products case. This is different from a products case.
It is also stated in costs, where a third-party manufacturer who is not in privity is sued for negligence and strict liability. It is mentioned in Jordan, I believe, where a third-party manufacturer is sued for negligence and strict liability. And the question may be, is it any torts that are barred by an economic loss doctrine? Are there certain torts? As I prepared for today, I thought, what if it's intentional fraud? If somebody, specifically in that meeting, the contractor and the architect and the engineer all intentionally lie to a prospective tenant, should the economic loss doctrine apply? I think there you have protections for intentional fraud, whether it's particularity in pleading and clear and convincing evidence, and that might be a distinction. But in standard negligence, standard torts, what is the impact on the contractual setting where we have an owner who hires a builder, and the owner is going to lease that space in a commercial setting for commercial purposes? Each of those relationships is governed by a contract. And should this tenant protect itself against purely economic loss by its lease with its landlord on when I get into the building, how I protect myself? Is the contractor architect entitled with the owner to protect itself against consequential damages, to pay liquidated damage if it's not done on time? Or are those relationships going to become simply a question of, can I get enough evidence to submit a negligent misrepresentation claim to a jury? And what is the public policy implications? If you look at the East River case, the U.S. Supreme Court that started this kind of discussion that you discussed in Head, is it a purely economic loss? Here it's clear. Is it something that can be insured against or foreseen or protected against? Yes. Are there contractual remedies that could protect people for that? Yes. In this case, we have some confusing facts because the building was both residential and commercial, but the space that this business was moving into was commercial space. I'm concerned about the Court of Appeals case expanding this kind of liability. Right now, we have the Het decision which says residential construction you can sue in tort. We don't know right now, other than the Court of Appeals decision in this case, when you can sue in a commercial setting for a commercial contractor for a negligence misrepresentation or another negligence claim. If we open that up, then there are less incentives for the parties to protect themselves economically through their contract. There are more risks to the developer, the builder, the architect, the engineer, as to what they might say to somebody at some time that might come back to bite them in tort.
It seems like, though, that it's a different discussion, perhaps. Let me back up. Part of the problem that we're having with the economic loss doctrine is that this court hasn't dealt with it until David versus Head. And the first case that we get with it is one that's sort of way down in the development evolution that normally happens in a state with the economic loss doctrine. You first sort of decide, do you apply it with products cases? Then you decide whether you expand it a little further and a little further. You're taking us even further down the evolution because there's no contract between Midwest Slitting and Morton. So we've got a separate corporate entity, and we have to. So here you're saying not only do we apply the economic loss doctrine in sort of all these other settings, but we also have to expand its application when, in a valid negligent misrepresentation case, the plaintiff does not have a contract with the defendant. And that's even a narrower application. I mean, that's a more extreme application of the doctrine. And so don't worry about the commercial residential distinction right now. Focus on the fact that these guys don't have a contract. And so wouldn't the economic loss doctrine bar even valid simple negligence claims, for example?
If they filed a negligence claim against Morton Buildings and said, you negligently built this building, I don't think the rule should be any different than if they file a negligent misrepresentation claim. Okay. Non-privity parties have been barred by the economic loss doctrine, as you noted, in products cases. In costs, the Caterpillar didn't have a contract with costs. In the Jordan case, the farmer didn't have a contract with the combine manufacturer. Now, those are product-type cases. They involve negligence claims as well as strict liability claims. I think the overarching question is, are there some torts where this court wants to dice it thin enough to say there are some torts where we're going to allow a tort recovery because of public policy reasons? That may be an intentional fraud case. It may be negligent misrepresentation. Is it negligence, strict liability, fraud, or negligent misrepresentation, all of the above or some of the above?
But what's wrong with just saying that the economic loss doctrine doesn't apply unless there's at least a contract between the plaintiff and the defendant?
The Court of Appeals criticized Morton Buildings and me, I guess, because we had Mr. Rinehart at the table. Why didn't we sign a contract with Midwest Slitting? I can't sign a contract with somebody unless they want to sign a contract. I guess the alternative would be if I know that the owner has a prospective tenant, who, by the way, had no lease, had no obligation to move into the space, planned to move into the space, but was not legally obligated to do so. If there's a prospective tenant there and I say, would you sign this contract for me limiting my consequential damages? I'll pay you liquidated damages if I'm late. Will you sign that? And the prospective tenant says no, then my choice is to walk away from the contract the opportunity for that business or risk a tort claim from this prospective tenant who has heard my presentation and may be able to take the time of contract and say, you didn't make that, therefore you lied to me. I think that's the kind of protections that you're going to cause people to take, which don't benefit the overall economic goal of let's let the parties figure it out. If the court needs to intervene in circumstances where we've intervened in bodily injury, we intervene where it's damage to another property, another piece of property, not the property at issue, and we intervene in residential construction cases where I think the main difference is we don't believe that there's an equality of bargaining position. Why the Kansas Consumer Protection Act treats consumers and individuals as sole proprietors differently than an LLC or a corporation. Those three things we have agreed we're going to alter the rule and we're going to apply it in those situations. The issue now, I think, in the evolution of Kansas is we've decided to apply it in products cases, at least at the Court of Appeals level. We don't know what this court will do and when you get the right case or the wrong case. We don't know what you'll do for sure on negligence cases. We know what you'll do on residential homeowners, and now we're trying to figure out in a commercial setting what you will do for a negligent misrepresentation case. We argued at the Court of Appeals, obviously, that we did not believe those alleged misrepresentations in the jury instructions are statements of fact. We didn't prevail on that. I think you can look at that, though, and determine in your source of the duty, do those kinds of misrepresentations stem from a common law duty not to mislead somebody, or are they standard contractual? In Het, is the gravamen of this complaint a contractual obligation or a legal duty imposed by law?
What's the restatement on negligent misrepresentation has its own internal limitations on the circumstances under which liability can be found. Why aren't those enough to protect your construction company or your contractor who's worried about the tenant or others who may justifiably rely on the false information that has to be found in order for liability to occur?
Well, I might mention there is a question of reliance here also because they didn't have any obligation to move
It's already
in
been found against. I mean, that's the problem here. You've got to assume valid negligent misrepresentation claims.
I'm
trying to figure out why these guys don't get to come to court.
I'm not familiar with all of the limitations that are within the restatement. But I think a practicing attorney in Kansas knows that it is not a difficult burden to state a negligent misrepresentation case. And that may be good because we want to deter that kind of activity. But in a commercial setting with the contractual relationships that occur in contracting and construction of buildings, that is not something that will benefit society as a whole. It will end up bogging it down, and it will end up with much more protective actions. That, I think, is ultimately maybe a policy judgment as to which the economic loss doctrine is as a whole. Is that something that we want to do or not?
I have one other question. I got confused in some of your papers because the prayer for relief that you ask for is a remand for a new trial. And I don't understand that because the way the statement of the issues is in the petition for review is this is a legal question and it's either a bar to the claim or it's not. And so why did you asked for it twice in your last filing with this court. Is there something I'm missing?
That was a misstatement. As to the economic loss doctrine, it is an up or down. There's no remand required for that. On the attorney fee issue, there might be. Certainly at the Court of Appeals, there was on other issues that could have been tried had the court found the other way at the Court of Appeals level. But no, there is no need for a remand on economic loss doctrine because either the tort was a valid claim or it was not.
One other question on the attorney's fee issue. Do you claim that this court did not have authority to adopt Rule 7.07, which is the one that permits the assessment of attorney's fees on appeal?
No.
Okay.
Did you intend to say anything else about any other issues? The reason I asked that, I would prefer that you not wait until your rebuttal to raise them because that kind of turns this whole process on its head.
I think we've covered everything through the questions, Your Honor.
All right. Thank you, counsel. Have any further questions? Thank you.
Morning. May it please the court. My name is Michael Ince. I represent Kenneth and Beverly Rinehart and Midwest Slitting in this matter. We have two issues before the court, as we've discussed so far this morning: economic loss doctrine and the attorney's fees that were assessed by the appellate court at the appellate level. I want to talk briefly on the economic loss doctrine. I feel it's fairly clear that we do not have a set of facts here where the economic loss doctrine is even an issue. The underlying purpose of that doctrine is to maintain a line between contract law and tort law. If you have a contract or if you have a warranty, you're governed by the contract law, and you're not allowed to cross that line and therefore assert a tort claim to kind of go around the contract and create additional duties. If you look at every case that's been cited by Morton Buildings, I haven't been able to find one that doesn't involve a single plaintiff asserting a contract claim and a tort claim, or a warranty claim and a tort claim at the same time. It's basically one plaintiff asserting two different alternative causes of action. And in those cases, the court has always said, no, you can't go at the defendant both ways, because you have a contract that governs your relationship. We don't have those facts in this case. In this case, we have two plaintiffs. We have the individuals, the Rineharts, who had a contract for a building that was to be constructed. They asserted a contract claim against Morton Buildings. We have Midwest Slitting, which is a separate legal entity, who also had a claim against Morton for some representations that were made at the completion of the project. That's the tort claim. We don't have either party crossing the boundary between contract and tort claims. They are both asserting their own claims. Neither are asserting alternative claims of tort and contract at the same time.
At one point, your individual clients did have a negligent misrepresentation claim.
They did, and that was probably a pleading mistake on my part, because I recognized the economic loss doctrine, and we conceded at the summary judgment, I think it was a summary judgment hearing, that we weren't planning on proceeding with the negligent misrepresentation on behalf of the plaintiffs.
That was my next question, is when it got dismissed. Okay, thanks.
Okay. The Het case involves the residential exception for the residential construction. Again, since we believe economic loss doctrine doesn't really apply, we're not really looking at the construction side of that set of facts. It's not Midwest Slitting is not asserting a claim with respect to a contract in the context of a consumer construction project. Their claim is purely for misrepresentations. It has nothing to do with the construction contract.
And just to be clear, did you just say those representations, the only representations that are alleged to have been negligent, are the ones made at the conclusion of the construction?
Yeah, it happened at the time when Midwest Slitting was looking to relocate. They'd previously been in a garage and needed to move into the new building, and Morton Buildings essentially said, this building is fine, it's okay to move in, it's up to industry standard, you can move in. And Midwest Slitting knew it wasn't, and had sold their existing building and had to move, and moved into an industrial park, and that's where their damages flowed from, was the last minute move to the industrial park, which involved paying rent, and that business wasn't designed to operate with a rent payment in their business model. So when that happened, they didn't have a lot of options. This business required three-phase power, and they didn't have that everywhere.
I understand all of that. Midwest Slitting Mr. Rinehart is the only principal in Midwest Slitting, is that right?
That's correct.
So these representations were made to Mr. Rinehart?
Yes.
And how did Morton Buildings know they were talking to Midwest Slitting rather than Mr. Rinehart at that moment?
It was discussed from the beginning that the business was an intimate part of this project they had planned, where it was in one half of the business. Whether he was wearing a hat as Midwest Slitting or as the homeowner, technically he was wearing both. They knew they were speaking to the owner of Midwest Slitting all along, because that was part of the plan to have the building. The problem we face with applying the economic loss doctrine is there is no contract here for Midwest Slitting. This isn't a construction contract dispute. They can't sue for breach of contract. They're not seeking the benefit of any bargain with Morton Building. This isn't a delay claim about when they get in the building. It was this building's done, take it, or leave it. We're done working on it. And they had to move elsewhere at the last minute, and that cost them a lot of damages because they had sold their other building. Midwest Slitting didn't have the opportunity to protect themselves in a contract because there was no contract. And you can say, well, they could have jumped in. It's the same people. But you got to think about what we're talking about here. It's basically contracting to tell the truth is what we're looking at, is what Morton has suggested. They are suggesting you could have protected yourself against lies, because that's what the claim is against Morton. False information used in the context of a business that caused damages. You could have contracted against false information. Well, general public policy, people don't think about things like that. You expect people to be honest with you in your business relations, and when they're not, you don't have immunity for that party. You have liability.
I don't want to split hairs, but we're talking negligent misrepresentation, are we not?
Correct.
To me, a lie intimates an intentional falsehood.
Okay.
If I tell you something and I don't realize it's false, have I told you a lie?
I can see that point. I wouldn't call it a lie. It's false information in the context of a business relationship. But most people don't contract to protect themselves against that, and that's why this court has adopted negligent misrepresentation as a valid cause of action for parties that don't have a contract but do receive false information, rely on it, and sustain damages. If the court doesn't have anything else on economic loss doctrine, I'd like to move on to the attorney's fees issue. The standard of review is somewhat of an issue before this court. It's our position that the standard is abuse of discretion, because we're talking about the amount that was awarded to the Rineharts. We haven't made a claim for Midwest Slitting.
I thought the issue was whether you had to sever out or separate the allowable fees or the fees for the allowable issues from the time spent on those for which there's no authority.
Yeah, and that is the analysis that applies. And I'll get to the analysis. But I think we're still looking at the amount that the Court of Appeals applied to the issues, as opposed to the standard that Morton has suggested, and that is whether there's a statutory basis for awarding attorney's fees. And they say that's statutory interpretation and subject to de novo review. I think there's clearly a statutory basis for awarding attorney's fees to the Rinehart under the Kansas Consumer Protection Act. So therefore, that's why I urge that the standard is abuse of discretion, and we're looking at the amount, and then you get to the analysis of the issues presented to determine whether it was reasonable for the appellate court to award the fees they did versus some other allocation.
Is it discretionary to determine the determination of whether the issues are so intertwined they can't be separated? I mean, that's the only way you get to all your fees, isn't it?
Yes.
Is that the Consumer Protection Act issue was so intertwined with all the other issues that it's impossible to separate out the fees.
That is essentially the exception to the general rule, which you've already stated. General rule is to divide the issues based on those that allow recovery of attorney's fees. The exception is when there is a determination that they're intertwined to the point of being inseparable. And
that was a discretionary function by the Court of Appeals, is what you're saying.
Yes, and it was also a discretionary function at the district court level, and they made that determination that it was impossible to divide the issues. And therefore, the district court made that determination. We don't have a lot of input on what the Court of Appeals did, but our assumption is they took that determination at the trial level, which was not an issue at the appellate level, that the fees were intertwined to the point of being inseparable, and therefore applied it and awarded all of the fees.
Do you think there's an issue on the attorney's fees that when the Court of Appeals awarded them, they cited only to Rule 7.07 and not to the statute under the Consumer Protection Act that permits fees for appeal?
You know, I hadn't picked that distinction up.
Let me tell you what I'm seeing and let you react to it, which is why I asked Mr. Musil the question about the court's authority. for 7.07. If you read 7.07, it says if the district court had authority to grant fees below under statute, then on appeal, the appellate court can award fees for the appeal. And to me, at least one reading of it might be, can award all of the fees for all of the claims, even if below you wouldn't have gotten them under the statute. There's no provision. And it concerns me that that is broader than the authority from the statute. Now, I guess if you didn't look at it, maybe you haven't thought this through, but just to present it to you, do you think there's an issue with whether the rule isn't broader than it should be? And I guess I'm saying that because it seems to me the only power a court has to award attorney's fees is if it's been granted to it by statute or by contract.
And I guess I hadn't thought of that interpretation, that they weren't looking at the statute down below or the statutory authority. I believe KSA 5634 provides fairly broad authority, and I don't know what the Court of Appeals did, but I don't think they relied on a broader authority under that Rule 7.
All they cited was the rule, and that's what's caused my question.
Okay. Well, 634 says you're entitled to attorney's fees if there's unconscionable conduct and the attorney's fees are for work reasonably performed. That, I think, is somewhat of a broad definition of what's allowed on appeal. Sometimes on appeal, the work reasonably performed gets broader, and in this case, Midwest Slitting went out of business, and the Rineharts were left with personal exposure on corporate debt. And so their issues on a personal level got a lot broader on appeal, to where they were fighting to preserve a judgment against a company that was out of business, had a lot of debt, and needed that judgment to pay the debt, or else the Rineharts become personally liable. So I know that's kind of an unusual argument, but it in fact is legal fees incurred to defend the Rineharts, the consumers in this case, who were taking on a lot of personal exposure under the Consumer Protection Act, and that's what it's there for. It's to protect the consumer from the supplier and their actions. And work reasonably performed, I believe that encompasses at that level, the appellate level. That's a fairly broad item that needs to be covered for the Rineharts.
But what you're saying, is that any different, though, than just the normal notion of you have fees incurred for the claim that for which you're entitled to fees, and then you can also get fees for claims where the evidence is intertwined between that claim? And are you making an argument other than that this is all intertwined?
No, I'm not. I think at the appellate level, the entire case is intertwined, given the circumstances and how the facts played out from the initial events and the interactions between the consumer and the supplier. The one point I do want to make with respect to the 5 issues raised on appeal, there is argument that only one issue involved Consumer Protection Act questions for the Court of Appeals. We don't necessarily agree with that. The 5th issue did involve the judge's determination that Morton Buildings acted in an unconscionable manner. That is clearly an item under the Kansas Consumer Protection Act. I'm referring to the issues in the order they were presented. The 3rd and 4th issues had to do with the introduction of some photos regarding the building. That clearly went to proving the Consumer Protection Act's claims, and also the measure of damages also goes to the Consumer Protection Act claims, because under the Consumer Protection Act, it is a comparison between civil penalties and actual damages. In this case, there were 6 deceptive acts confirmed by the jury by Morton Buildings. That could have produced a civil penalty up to $60,000. It's $10,000 per deceptive act. That number has to be compared to actual damages for the purposes of awarding damages under the Kansas Consumer Protection Act, because the consumer is entitled to the higher number. Therefore, the issues 3, 4, and 5 are all related to the Consumer Protection Act. Issues 1 and 2, which is the economic loss doctrine we're talking about here today, and then another attack at that negligent misrepresentation claim, those were Morton building versus Midwest slitting type issues. But again, as I've said already, at the time of the appeal, the Rineharts were acting to protect themselves from personal exposure that would have evolved if those judgments somehow went away at the appellate level because of the economic loss doctrine. So with those arguments, I have nothing further unless the court has any questions.
We have any further questions of counsel?
I do have one. I guess I'd like for you to address the appellant's argument that, if we agree with you that the economic loss doctrine doesn't apply in this case, what's that mean in a broader setting? Developers who have many potential clients in mind, or tenants in mind for their buildings. Does that mean any potential tenant down the road, as long as it's within the limitations period, can bring a tort action against your builder or your contractor? You don't, even though there's a contract with the developer? I mean, how far can we extend this?
Well, those situations all involve relationships that are governed by contract. And to the extent that you have those relationships governed by contract, the economic loss doctrine is going to remain in place. But when you have a situation where those contracts don't exist, the fallback for...
But isn't that the problem of your client, that a contract doesn't exist here?
I don't know if it's a problem.
I mean, there's really
it's
no
a problem.
equity here for your client, in my mind, I guess.
Okay. It's a problem. I don't know if it's a problem for them that they don't have a contract, so they can't sue under a contract, but they still have alternate means for bringing an action when false information is conveyed.
Because they don't want to sue themselves, basically.
Well, and there's no contract to sue themselves under. But it all flowed from the representations that were made as to the building.
Isn't the unique circumstance here that the representations were made to the future tenant? If you have someone building a mall, then the builder is typically not going to be making direct representations to the future tenants. And without those representations, there's no cause of action for negligent misrepresentation.
Yes, I would agree. It all comes down to the facts and whether the economic loss doctrine can be applied to the facts as we have them, because the woulda, coulda, shoulda, had a contract argument is something to consider, but in the context of a construction litigation where we have the tiered contracts, everyone's tied by contract, their duties are defined, but this isn't that set of facts. This set of facts involves no contract, representations to these people that they relied upon in their business, and it ended up costing them a lot of money. Therefore, it's hard to imagine, or I don't think we have that case where the parties are all governed by contract. We have a case where they aren't governed by contract, and if you look at what Midwest Sledding has, if they don't have a negligent misrepresentation claim, what do they have? They don't have a contract claim. They don't have a warranty claim. Essentially, Morton Buildings is looking for immunity on this item. It costs the business a lot of money, and they're saying, well, they don't have a negligent misrepresentation claim, but we don't know what else they have. They're going to say they could have contracted, but they didn't, because people don't think about contracting for honesty or truthfulness. That's expected, and when it doesn't happen, this court has adopted negligent misrepresentation as a potential liability for the company that conveys false information.
Any further questions of counsel? I see none. Thank you, counsel.
Thank you.
You had reserved 3 minutes for rebuttal.
I'll be brief. Justice Moritz, your question is the key question from a public policy standpoint. Because although Mr. Ince says all of those relationships are governed by contract,
Right.
they're not contracts between the parties.
Right,
The owner of the land has a contract with the developer.
right.
Who has a contract with a general contractor who hires an architect, an engineer, and some subs. And then if it's an office building, there may be 20 prospective tenants, all of whom are pitched by the developer for pre-leasing, so that the developer knows, I can build this because I've got 5 people that have leased and I've got 5 people that are prospects. The only contracts are up the chain to the owner, and then the owner's contracts down to his tenants.
Everybody's protecting their risks.
Everybody protects their own allocated risks.
Right.
But if a tenant can sue the architect for negligent misrepresentation or negligence, or the contractor, or the developer could sue down the line, that is what is the problem. That's what leads to the issue. And I understand that the negligent misrepresentation finding is a difficult issue here. But as Justice Johnson said, negligent misrepresentation is a negligent communication of information. Just like a negligent failure to pour the concrete right, or a negligent failure to hang the ceiling correctly. Is it so dramatically different that we're going to say, in that case, we're not going to worry about the contract allocations, we're going to let everybody that doesn't have a contract sue anybody else they want for negligent misrepresentation or negligence, particularly when the negligent misrepresentation alleged is when the building will be done. A contract type duty. That's the difficulty. And this case is unique because it's got the mixed building and it's got the mixed people, but it's not unusual for a developer or an owner to have a subsidiary company that is going to be a tenant in that building. And so if I'm the owner, I'll sign my contract with the developer or the general contractor, and I'll have my company, or maybe it's me sitting there as ABC LLC, that's going to be a tenant. Well, if something goes wrong, ABC can sue its parent company for the lease requirements that it signed under the contract and protect itself there. Or it can sue the third party. I won't sue my parent. I'll sue the contractor over here for negligence because I don't have a contract with them. That's what opens up doors that I'm not sure we want to open up. On the attorney fee issue, 707B is not clear. Statutorily, the only way that anybody who received attorney fees in this case was under the Kansas Consumer Protection Act. Most of the Court of Appeals work, argument, decision was related to economic loss doctrine. All of it here. I think you have expanded the reach of the Kansas Consumer Protection Act if you allow a consumer and their single member LLC to recover 100% of their fees when the biggest jury verdict, $149,000 versus $108,000, is for a commercial entity that isn't entitled to KCPA fees. And I'm not sure how far we want courts to delve into that, but I think as a fundamental matter, there is no right for Midwest Slitting to recover its fees, and under the Court of Appeals decision, it has recovered its fees.
Earlier in your argument, excuse me, you gave us a list of some criteria for when this doctrine could apply: foreseeability, potential of insurance, risk allocation, some of those sorts of things. But as we talk, and as you have just in your closing comments threw out another qualifier, which was that the date of the building completion is a contract type of agreement that you would reach. What's striking me is that if we may not want to open too many doors, but how do we know which doors to close and which doors to open? I mean, how do you write this animal in a way that it's applicable from one case to another, or that we at least know what we're trying to achieve, or whatever?
I think we've started that evolution. As I mentioned, bodily injury doesn't apply. Damage to another product doesn't apply. Residential homeowners, unequal bargaining position doesn't apply. Those are standards we have, and those are standards consistent with East River and that you applied in the Het case. The foreseeability, the economic efficiency, the ability of somebody to protect themselves by contract, the impact on particular commercial transactions, those are things you have to weigh. And I don't have a magic elixir distinction to offer to you. I think what you have done thus far today is consistent with what most other states have done and have been careful in extending elimination of the economic loss doctrine into construction contract cases where you have a very defined contractual relationship among multiple parties, and rather than let them start shooting at each other in a circle, we make them go up the chain. Mr. Ince said Midwest Slitting had no remedy. Well, in any other construction case, it would, because it would have a lease with its landlord that would have said, I get to be in by X date, or negotiated remedies. In this case, there wasn't a lease, there wasn't an obligation to move in, there was also no remedies that had been negotiated. I don't think we want to encourage people not to protect themselves in those remedies, and rather wait to see if it works, and if it doesn't, sue somebody in tort.
Of course, your client knew that they hadn't protected themselves, and that they were essentially dealing as one entity here, it seems. I mean, that they were taking some risk, but so was your client.
I think going forward, depending on what your ruling is, a contractor would know for sure that if Midwest Slitting is sitting at the table, acting as a consumer, but with the hat on, with two hats on, I have to deal with them and either get a contract with them, a release, limitation of damages, something, or I have to walk away from the project if I can't balance the risk. And you're right.
Or build it correctly.
Or build it correctly, Justice Johnson, absolutely. Yeah. And everybody that's built buildings know that doesn't happen every time.
Any further questions of counsel?
Thank you for your time.
Counsel, thank you both for your arguments this morning. Court will take this matter under advisement. This time the court is in recess for 15 minutes.